And it is a great pleasure to introduce our next presenters, two people that I'm very fond of, that will be presenting on A to Z in estate planning, probate, trust, transfers, and much more. So Nick Halbur completed his Juris Doctorate at the University of St. Thomas School of Law in Minneapolis in 2006. He began his legal career teaching the Elder Law Clinic at the University of St. Thomas, where he represented clients, supervised students, and taught a classroom component. After 3 years of practicing in Omaha, he joined Elder Law of Omaha in 2014, and he presents CLE and other community education seminars, primarily on estate planning and Medicaid planning. His practice focuses on estate planning, probate, and long-term care planning, including Medicaid. Joining Nick is the Margaret Schaefer, who is a tremendous colleague. She is the rock star in the world of elder law. She is the managing attorney of the Centralized Intake Unit at Legal Aid of Nebraska. Margaret received her Juris Doctorate from Hastings College of Law in San Francisco, California in 1991, and has practiced law in both Idaho and Nebraska. Margaret has been at Legal Aid since 2005 and has managed the Elder Access Line since it opened in December of 2005. Margaret's practice focuses on the legal issues low-income elders face in Nebraska. And if you'd please join me in welcoming Nick and Margaret. So thank you both.
Thank you.
There you are.
All right, well, I am Nick Halbur, and this is Margaret Schaefer, and we're here to cover very quickly, in about 45 minutes, a bunch of estate planning and other things, basic stuff that seniors and their families need to know. First, we'll start off with your basic estate planning. It's planning for, or at least what people primarily think of is the planning for after you pass. You make your wishes known in your will, right? Your will is the legal document to give people the idea of what to do with my stuff after I'm not here to tell you anymore. So that's your legal avenue to do that. It helps you and your family wind up all of your affairs, and gives you the guiding light, and helps the family also, even if most people are giving it to a spouse or to their kids, and we'll talk about intestate and what happens without one, but the will does, well-drafted will skips some steps, speeds up the process, and really is a great service to those who are left. And most of estate planning, the way I talk about it with my clients, is a favor that you're really doing to whoever is going to help you anyway. You know who's going to be there. Most of us know who's going to be there, who's going to take care of us. And we're just using estate planning to make it easier for them to do what needs to be done. There's a wide range of estate plans to fit every person, to fit every Nebraskan, depending on their level of wealth. The experience of dealing with your estate will obviously be influenced greatly by whether and how much debt you have, and who do you want to receive the property. Frankly, the more boring your plan is, the less likely it is to be controversial or contested in any way. But it's still your stuff, and if you want to give it to the neighbor, or you want to give it to an old friend, or just one of the kids, it is your stuff, and you have the right to do that.
So property is not always owned by just the individual who's passed on. Many times we own property jointly. I mean, for example, my spouse and I own a house together. We have a few cars, we've got some bank accounts, and then some of our accounts have beneficiaries. I have a life insurance policy, so I have a beneficiary on that. So the first thing to look at is jointly owned property. Real estate can be owned a variety of ways. If you own your property with another individual as joint tenants with right of survivorship, if you pass on, that property is owned by whoever you own it with as a joint tenant. So that means I may say in my will that I want my house to go to my cousin George, but if I own it jointly with my spouse, that property is his regardless of what I've put in my will. Now, I might own a property as tenants in common. This means that I own my share and whoever else owns the property may own their share. And if I pass on, then that property, my piece of that property would go to who I designate. So for example, if my siblings and I were to own a house in Vail, Colorado as our ski resort for our family vacation home, and it was owned as tenants in common, when I pass on, my share might go to my children or my spouse or whoever I designate, rather than going to my siblings for them to own that house and own my share. This is certainly true on vehicles too. Since my husband and I own our cars, those cars are all mine. Now, I probably don't need the F-150, but it would be mine just the same as anything else. Same with bank and investment accounts. I mentioned a bank account, my checking account. That's my account, I can spend every dollar in it, but it's also my husband's account and he can spend every dollar in it. It's owned jointly by us, so if he passes, it's mine, if I pass, it's his, it's just our joint account. Sometimes an account will have a payable on death. That means it does not today belong to somebody else, like a joint account is, but if I passed on, it would belong to somebody else. It's a future interest. So if I have a single account, I'm the only holder on that account, that's my checking account, but I have a payable on death, that my daughter would get that account at my death. Right now it's my account, I can use the money, I can do what I want with it, she cannot touch it. But when I pass on, now it's her account, and she can do what she likes with that property.
And then there are non-probate transfers, so ways to transfer funds at your passing that actually don't involve joint ownership. So the newest kind of deeds have been around forever, right? That's how they transferred property in jolly old England, where we got a bunch of these laws from back generations ago. The newest development or newest version of it is a transfer on death deed, which is available in lots of states. Specifically in Nebraska, the transfer on death deed takes effect when you die. So it doesn't, so again, like the bank account that you could use up before it transfers on death to somebody else, you can sell your house after you do a transfer on death deed, if that makes sense, because there's not a current transfer. And the owner has no rights in the property until you die. They go down to the county recorder's office. If you died and you were still on title, they take title with a combination of the transfer on death deed being filed and the death certificate and the proper paperwork. Now, one result of something that's new in a precedent-based system like ours is that there are some unintended consequences. There was a gentleman in Minnesota who received a property by a transfer on death deed, and the property actually burned down 5 days after his mother died. I think it was his mother. There was some foul play involved, not his, but State Farm didn't cover it because he was not on title. It didn't transfer in the same way that some of these other deeds or a probate would have transferred the rights under the insurance policy. So that was a very unintended consequence. There's a lot of lawyers in Nebraska and throughout, probably throughout the country, certainly the Eighth Circuit, this was a federal case, who were sending a lot of letters out to clients who got transfer on death deeds to have them update. If you can get your insurance company to list your transfer on death deed beneficiary as an additional insured, that's probably the best step that you can take and do your due diligence. Investment and bank accounts payable on death beneficiaries, again, you can exhaust as much of those accounts as you want. You have full access while you're alive, and again, they'll be asked to fill out a form at the financial institution, probably provide a death certificate, and they should be able to get the property, and there's a proper transfer on death title to vehicles. Those all function very much the same way. These are all non-probate transfers. I would point out that the Nebraska inheritance tax should still apply to most of these, to pretty much all of these transfers that we've discussed, I think. And of course, life insurance is the big, life insurance that pays directly to beneficiaries being the big way to avoid that particular tax. So what does a will do? Push the right button.
There you go. People often think that everybody needs to have a will, and actually, we generally recommend it. A will does two basic things for you. The first thing it does is it establishes a personal representative. We think of that as an executor or an executrix, but in Nebraska, the term is personal representative. We also recommend that you have an alternate, because life does not always happen in order, and people aren't always available when you think they're going to be. So having an alternate personal representative is really a good idea. That's the person who's gonna take care of stuff. They're gonna pay your bills, file a probate if necessary. We're gonna talk about that in a minute. They're gonna distribute things. They're gonna make some decisions. So it's good to have your personal representative be somebody who gets along with the rest of the family and can work well with them. The other thing that a will does is it establishes your beneficiaries. A beneficiary is different than your personal representative. Your personal representative does not necessarily get everything, and generally they don't. The beneficiaries are the people that get your stuff. So for example, you can set out that my car is gonna go to my daughter, and the F-150 goes to my son, and whatever it is that you want to set out as far as your beneficiaries. Those are the pieces that a will does. There are misconceptions. I've talked to folks on the elder access line before, and they say, well, I need to have a will because I don't want the state to get my property. That's not how that works, and we'll talk about who gets your property when you don't have a will next.
All right, so without a will, which you may find yourself in this situation after a loved one dies, if you haven't followed our advice on this seminar, your family, your blood relatives, and your spouses will receive your property depending on their relationship to you intestate. But it goes in a very, lockstep mathematical way that matches some people's wishes, but not everyone's. Each person's situation is unique. There's a looking up and looking down through the family tree kind of search pattern that the statute lays out. But I like to, just as a way to illustrate one part of the statute that I think is not necessarily what a lot of people look like. I put section from the probate code, chapter 30, 2302 in there, the share of a spouse. The intestate share goes through a lot more conditions than you'd think. A lot of people just assume it just goes to the spouse, but if you see it's more complicated than that, and maybe you want it to be, but maybe you don't. If you don't, you need the will that says everything to my spouse. If there's no surviving issue or parent of the decedent, the entire intestate estate. So only if you have no surviving issue and no parents living, is it such a clear answer. If there is no surviving issue but the decedent survived, then the first $100,000, one half of the balance, which is very similar to the elective share, which is what the spouse can get if they get written out of the will, which is always exciting when you see spouses written out of the will without a prenup. Those are usually, in my experience at least, homespun wills, done without a lot of legal advice, which have their own whole set of problems and expense and delay, frankly, for the family. If there's some living issue, all of whom issues, depends on whose their parents are, and then you have this first $100,000 and the first half again. If there are surviving issue, one or more of whom are not issue of the surviving spouse, one half of the intestate estate. So there's at least 3 different possibilities for what your spouse will get intestate, if depending on, obviously you're married at the time, but whether parents are still around, whether kids are still around, whose parents they are, etc. So it is actually, that's I think the best example in the intestate statute of it's not as obvious an answer as people think. Oh, it'll just go to my spouse. Clearly not. This is the law that would apply, and I think it's not what a lot of people would want. So I point that out.
Right, and that does work in conjunction with what we talked about before when we were talking about jointly owned property. Because then it's what is part of the estate, and is this jointly owned property part of the estate or not? So it can be, it all works together.
Right, the intestate succession statute would apply to the probatable property,
Right.
The property that does not have those other ways of getting to someone. And of course, the spouse can get at those properties as well through a different spouse. That's beyond the scope of what we're going to talk about today.
Right. So then comes the next question. Now that I have a right to this property, my parent or my spouse or my child has passed on, and I'm the beneficiary, or I'm entitled through intestate succession to some item. Maybe that's a bank account, maybe that's a home, maybe that's a vehicle, maybe that's a rebate check from something. And we get this a lot on the Elder Access line where somebody says, I got a $500 check back from the insurance company for some monies that were paid, but it's made out to my deceased spouse, or it's made out to my deceased parent. And there's no probate, there's nothing, and I went to the bank and they said I had to file a probate, and that's gonna cost me thousands of dollars, it's not worth it to do it. How do I transfer those items?
Don't necessarily take the bank's first advice.
Right, no, that's generally good. Call the Elder Access line. What we'll tell you is you need a small estate affidavit. A small estate affidavit, there's two different forms that we use. They can transfer any asset in an estate that's worth less than $50,000, which is a whole lot of stuff, because this is what's left over, just like we were talking about with the intestate succession. This is the estate that's left over after we have joint property addressed and any informal transfers of property, any beneficiaries, payables on death, anything else, then what's left? So what are we looking at? What do you have? That's the first question that we need to see. What needs to be transferred? Because I get folks who call up and think they need to do a probate, and I'll ask, what property of the deceased needs to be transferred? And they'll say, well, there isn't any. Well, then there's nothing to be done. You don't automatically have to go to court because someone has passed. So you can transfer real estate or personal property for less than $50,000. There's a form. You sign the different pieces, you make sure you've met the requirements, you gotta wait, it's 30 days, you gotta have a death certificate, you wanna have the will if it's passing through a will. And then you sign it in front of a notary. Affidavit is a sworn statement. And you use that document to go to the bank, to go to wherever you need to go and get property transferred. So when we're talking about that transfer, and I'm giving advice on that, I'm gonna start with, what do you need to do to take care of each item? And once you get it all down and there's nothing left, you're all good to go. But these do save a ton.
Then you can skip your probate.
That's right, skipping probate, and that's next.
I will say, we were just noting out in the hall, the small estate affidavit statute was amended this year. The amount's still the same, it's still 30 days, the core of it's the same, but for any of the attorneys in the audience, you'll want to be updating your small estate affidavit forms this year. It's LB 501, it was part of a bigger package, it's kind of in the middle of what passed as LB 501 in the last legislature. Very small changes. It used to say there's no probate in any jurisdiction. Now you only have to say there's no probate in Nebraska. So apparently you can have a probate in another state and still use your small estate affidavit here if there's just Nebraska property, I guess. You do have to attach the will. I'd been doing that anyway, but now it's actually required if you're depending on a will.
Good practice anyway.
Right, it was always a good practice, and now you have to do it, so it's minimum practice now. And then kind of a very peculiar change, but you used to swear that there were no other claims on the estate, and now you can give the names and addresses of other potential claimants. So 3 or 4 little changes to your form. You can actually transfer real property by these affidavits as well, which at least the way I read it, is a separate $50,000. You gotta have a parcel that's tax assessed under $50,000, which doesn't do us a ton of good in in Omaha, but there are a few of those, around the state, and even in Douglas counties, Lancaster counties probably has some significant ones, and that will save you that part of it. Especially if you're doing that, you want to advise the client or do it yourself. I know we have a more broader audience than I'm used to speaking to today. That the Nebraska inheritance tax will still attach to that real property. So when you go to sell it, if you took it by reason of anyone's death, you didn't do an inheritance tax determination, that will slow down your closing. If there's inheritance tax owed, it will be the tax and interest if it's been over a year since then, which a lot of these family properties, of course, are in the family for quite a while, and the interest and penalties can add up, even though, of course, the inheritance tax is, if you're a kid, the 1%, but if you're in one of those other categories, nieces, nephews paid like 13, so that can add up pretty fast.
Well, and the value of the real estate is at the time of death. So if you're looking at doing a transfer for property that the deceased died 10, 20, sometimes 50, more than that years ago,
Yeah.
you want to look back at that old value.
Look at that value. Yeah, get those old tax records out and try to, don't use your 2021 value for sure.
No.
All right. So like Margaret was kind of indicating, I always joke or say at the beginning of my probate consults that probate attorneys are very lazy. We're looking to not do a probate in most cases. If I can avoid it and you get your stuff faster, I just get my little whatever I get, little bitty fees for giving you a small estate affidavit or whatever. That's fine with me. And come back and do your estate plan here maybe. And we don't need to clog up the courts with any more probates or any more proceedings than necessary. So, are there any assets that we can't get to into somebody else's name without the court's authority? And that's the probate court, right? That's the court authority that says, take this asset, and put it in the widow or the kids or whoever's name. With all these other alternatives we've been talking about are other roundabout ways, and probate, even though in some sense it's the court authority, it's the most powerful, in many senses it is the backup. It is only after you've exhausted all of those other means that you would go in and do the probate process. Not the boogeyman here in Nebraska that I would say it is in some other jurisdictions. You hear about years and years and stuck in a labyrinth of court proceedings. If you do an informal probate, for instance, you can start it all on the filings. You don't even appear before the judge. It's approved by the court staff. You have some built-in waiting periods, which is probably the most, aside from the cost, the most annoying part of it is that you do have to sit and wait for creditors to maybe show up, maybe not. You do have to, and you do have to do all the filings, the set of initial petitions. You have to get the letters. You got to go around and collect the property, file an inventory, publish notice in case anybody was owed money, and all of that. And again, after you've done your non-probate transfers, after you've done the small estate affidavits, there is a question in some very small estates where we can't get things transferred out, whether the assets justify the investment of time and funds, especially for some of our more low-income families. Is it really worth it if it's just over $50,000? It's not. The probate's clearly shouldn't cost you anywhere near $50,000 to get that through. But what creditors are out there? Because you can get stuck as a family member because you're lower priority. I think we said the will or the intestate statute going to beneficiaries, that's after all the other people. They're actually the last folks. They're the ones that get mentioned in the will. They're the ones the decedent cared about, but the law actually puts them last. You start with administrative expenses, your court fees, of course lawyer fees, because we're always there when they're writing the rules, so we're first. Let's be honest. And then you get certain special creditors like the burial, last illness, You get through, obviously secured creditors have a special place with regard to the secured property, like the mortgage on a house or the lien on a car. And then general creditors, anybody who's just has a legitimate claim, credit cards, other kinds of consumer debt are often in that big space. For elderly folks, you will have to notice the Nebraska Department of Health and Human Services and their estate recovery department to see if they claim to have an estate recovery claim for any Medicaid benefits they might have received. You go through all of that, and then assuming there's something left, and there won't always be, is my point. And for some people, entering into this is not always a great deal, and you take on all those responsibilities. When you sign up to be the PR of an estate, especially in an estate where you know there's going to be a lot of debt, you're taking on the legal responsibility to methodically go through that whole priority list. And frankly, your duty is to those creditors. They have to get satisfied, and you have to satisfy that duty before you get your own check, and before you get to write the checks to your brothers, sisters, nieces, nephews, whoever you'd like to give the money to. So that is a question. Some people, certainly have clients who go forward even with not great prospects of getting a real substantial inheritance out of a sense of duty, what have you. Lawyers don't like that kind of thing. We like our clients to take on legal responsibilities that are profitable to them and have more of an upside. Maximize benefits, minimize liabilities, right? That's our shtick. So the benefits of the probate process, obviously, first and foremost, access to the funds, right? That's why you came in, because Dad passed. He wanted me to have his funds. I want to get them. Do I have to do probate? You answer all those other questions. Yes, you access the funds. You step into mom, dad's, uncle's, whoever's shoes, and you have access to it. You get your letters of personal representative issued by the court. That's like, I call it their badge. Show this to the banker, show this to everybody, and they know you're in charge. I'm sure, I bet the first speaker from this morning has seen some fake letters of personal representative. If you've seen a fake FBI badge and fake powers of attorney, I'm sure he's seen fake letters of personal representative as well. See, we were talking about how hard it is to predict how these people behave and how to predict them, but I think maybe that's one that I haven't seen yet, but I bet that's out there. The fraudsters and their way of looking at the world. Speaking of the creditors, if you're worried about them, but you think there's maybe enough money to cover it all, if you go into the probate and you do follow all the rules, you do the methodical system and meet all your deadlines and accord to your duties, when you get your check at the end, you're in the best legal position possible. You did your due diligence, you went through the procedure, everybody else had their chance to make their claim, and that protects you, right? In a way that maybe the small estate affidavit or other types of transfers just can't deliver that same level of legal protection. So, for example, the sort of nervous beneficiary who, who's doesn't know a lot about the senior who died maybe, or just doesn't know a lot about their finances, may go ahead and sometimes even skip other alternatives and do the probate process to protect their own personal assets because the probate court does afford that protection. If you follow the rules, you're protected, and once you're on title, you're very much free to go. Of course, the first and foremost, the delay. The process is largely made up of enforced waiting periods. I say, the main job for most folks is to meet with me, come back in a week and meet with me to get it started, then meet with me every couple months until we're done and we file the different things that need to be filed along the way. But if the benefits are worth it, then you do it. And then of course the expense, the darn lawyers are always a concern. So probate's generally, like I said, not terrible, not a terrible boogeyman. I think, I tell people the absolute minimum to actually wait through all the waiting periods, if you file everything like on the first date you can, or as early as possible, I think is like 5 months in the state of Nebraska from the time you get your letters to when you can close, or at least when you can close informally, which is far less expensive, avoids court fees and significant lawyer time. The classic way, most well-established way to avoid the probate process is to do revocable living trust planning. And so you can fully administer the estate with a properly funded revocable living trust, which means a trust that the individual, in my case, client forms, and they actually get their title to all of the relevant property into the trust. So you deed the house into the trust, you list all of your bank accounts as trust accounts, and you actually usually do a will as well, which is called a pour-over will, that wills everything to this trust, so that if I missed anything, it'll get put in there. But the trust essentially has the terms of a financial power of attorney, because your trustee could take over while you're still alive and run your finances through the trust. And it has all the provisions that you would see in a will to effectively administer the estate. You still have to do an inheritance tax determination to properly administer it, so that is technically a court proceeding, but it's like a very small chunk of a probate, essentially, that you still do have to do. In some counties, just anecdotally, they do technically open a court file, but clearly no appearance, no need to travel to the courthouse. Usually just negotiated. For those that don't know, the inheritance tax is paid to the individual counties in Nebraska, and so you're dealing with the county attorney's office. One of the best, one nice feature is that there's no gap in the authority for the trustee. She's gonna get me a water. You have with a probate, you have to wait to get appointed before you can do anything. You want to talk about it?
Sure. When you have a probate going, you have to file that document with the court. You file the will with the court. So anybody can go down to the courthouse and look up and see all of the details of what you want in your estate plan, and who's your PR, and who gets this and who gets that. It's all there as public record. The terms of a trust, though, are private. They are not part of the court proceeding, so there's no public filing for somebody to go look it up and check it out. So anybody who wants to keep things more private, a trust is more the better way to go to keep that going.
Thank you for saving me there.
Thanks.
Right, and there are also great options with trust planning to deal with more unique situations. Spendthrift, which is the kid who's bad with money. Special needs trusts to deal with disabled beneficiaries, even a disabled spouse, or a spouse in long-term care. We pretty routinely use a trust strategy. If, say, the well spouse is to die first, we fund a special needs trust for a Medicaid spouse who's in a long-term care facility on Medicaid. That's been a very successful strategy for my clients. There are, of course, lots of uses of trusts. Now, these are, trusts are, one way of describing trust is giving lawyers the opportunity to write their own set of rules, which is like a dream, right, for us, because you can, there's default rules in the statutes, and there's all sorts of default rules, but it's essentially one of the few opportunities where lawyers get to write their own set of rules for their clients, and that's just too tempting, right? I mean, we love that stuff. Because we can always think of something better than the way it's always been done. So a lot of them are geared towards federal estate tax planning, avoiding the federal estate tax, which is not terribly exciting for me right now. I mean, it's the exemptions at like $11 million per individual.
Right.
So I don't really worry about that too much. But there are, a number of lawyers who make a very good living trying to avoid that tax. Asset protection, like I said, the spendthrift, it could be a pre-planning. We use some irrevocable trusts in asset protection planning, try to fund the trust and protect it from creditors. For my clients, sometimes the liability for long-term care with enough lead time, you have to have either a lot of health or a lot of wealth, or a combination of the two to get through that 5 years sometimes, and the willingness to give up some control, but you can get it there. And of course, a big part of our practice, special needs planning. Special needs trusts are a part of federal law that if you put your own money into a properly designed special needs trust, the beneficiary can still receive basic subsistence level benefits like SSI and Medicaid, and then there's some payback provisions for the trust. If the trust has anything left after the person dies, there's a payback provision to the agencies that provided the benefits.
Yeah, that allows a special needs individual to get things that the benefits don't cover. That might help them and increase the quality of life.
Right. I have one special needs trust that's paid for a whole lot of monster truck rallies. They go get tickets and go to that, and theater events, guitar lessons, quality of life things, and travel to the extent that the disabled person can travel. That's a great opportunity for them to be able to go along, even pay for the accommodations to their disability, if they want to make a trip somewhere, or just to see relatives and things like that. So.
Right, and those are things their income wouldn't allow, and so that special needs trust really helps make a difference. Okay, were there any questions before you have questions?
Oh, we do have questions.
Awesome.
You said something controversial.
Uh-oh, I think it was you.
Maybe. All right.
Okay, let's see. I'll let you do that one.
Would the transfer on death deed still have to be listed in the will? No. Again, all of those types of transfers, the transfer on death, the joint tenancy, joint ownership, are all going to remove those assets from what the will can affect, all right? So like the general rule is, if you're gonna do a will, that's great, you should, that's a very responsible adult type of thing to do. You're a grown-up now, right? I mean, some of my clients aren't getting their first will until they're 80 years old, but it's the responsible adult thing to do, to have a will. But no, if the transfer on death deed removes it from your name at the instance of your death, thereby removing it from the probate estate, which is what the will can affect. Certainly, you could recite that you have made other provisions and things. Those don't have a lot of legal effect, although they can stave off litigation if there's misunderstandings about how percentages should be, and that's not fair because this was transferred this way. So if you have significant assets transferring by a TOD, transfer on death deed, or other non-probate means, I do encourage clients to mention that in the will so that it is clear that that is part of the overall plan, and there's not a misunderstanding that they were somehow manipulated or misunderstood the overall effect of where their wealth would go.
This question has to do with burial and disposing of cremains and such. The question is, any details on cremation in terms of next of kin signing an authorization for a cremation to happen? Do all the children need to sign for a mother upon her death? They have a participant who has a client concerned that a son who has a guardian would be asked to sign something like that, and he wouldn't understand, and it would be very difficult for him. You can include in your will, or I think even in just an affidavit, your burial, who you want to take care of your burial, and who's the person that's in charge of that, and take care of those details for you. I don't know how you like to handle those.
I've had it, I've seen it mentioned in healthcare power of attorneys, because it is often sort of in that same vein of, you know, how to take care of the body while I'm alive, how to take care of the body after. And of course, the healthcare power of attorney is notarized, so it is an affidavit.
Yes.
So it would meet that requirement. But yes, it's an excellent issue to address in some formal way. You know, and yes, I think the official standard is that it has to be by affidavit. But you know, there's a lot to be said for just mentioning these kinds of issues in your estate planning and getting them in there somewhere, especially if you do think there's going to be an issue and you think there's going to be any dispute. The two key things that I say to clients is, you know, if you want to do what you can, there are some families where there's going to be a fight.
Yes.
They will find a way to fight about things because they have that level of dysfunction or, you know, old bad feelings in the family, and they will look for a way to fight. But if you want to avoid at least giving them anything good to fight about, mentioning these controversial topics is always great, and a lot of those, I think it does go a very long way with most people that mom wanted it this way, she wrote it down, it's in her will. And that does end the issue for the vast majority of potential flare-ups, you know.
And if you've designated a particular person to take care of this for you, that helps. They would be the ones to make those arrangements or make any signatures. And the rest of the family just can participate as they need to and as is appropriate for each family member. But it is good, and we often do include some information about preferences for what you want for your burial or cremation. As Nick said, it helps to make things go a little easier. Keep in mind, though, that probate, estate planning, those sorts of things, last will and testament, it doesn't work the same in real life as it does in Hollywood. So we're not gonna have this big meeting the day after someone's passed on in which we have the reading of the will, and it has
How many readings of the will have you done, Margaret?
Never, not once.
That's
Not
zero
once.
for
Yeah.
2 on us.
But then I'm not in Hollywood.
I offered to do one once. I mean, I had somebody call and offer, and I said, that's fine, but you're gonna pay me by the hour, and it's a pretty long will. And then I just asked them, can you read? I mean, I think that actually, if it was ever a thing, I think it was like medieval Europe.
I think so,
where
too.
there was like
People
the
didn't
lawyer and the doctor and the priest were the only ones in town who could read.
And it works great in Hollywood.
And it makes for a
does.
great scene.
It does.
But it's not a thing.
So we do definitely recommend that you put your will in a safe place where it can be found as needed.
Yeah, you gotta tell somebody where it is.
Yeah, and they need the original. And any of those trust documents that you've had prepared need to be located. That's true with all of the powers of attorney and healthcare powers of attorney that I've talked about in previous years. Make sure people can find your stuff. Don't lock it in a safe deposit box where they cannot get access without a probate, and they can't do a probate without the will.
Right, the safe deposit box, you can add them to the signature card
Right.
and make sure they know where the darn key is. I did have one family who paid a very pretty penny. They paid me to sit in the lobby. They actually paid more to the drill guy. His bill was very impressive. That must be a good living if you can get it. But you gotta have some pretty heavy duty equipment. But he got paid very well to open an empty safe
There's nothing
deposit
in it?
box. There's nothing in it. A little lint.
Oh dear.
But that was like a $600 piece of lint that family got. So somebody's got to know where it is.
Gotta
and
have access.
If you don't have the original, the judge will be calling you in. If you want to probate a copy, you're going to have a live hearing, and the attorney is going to have to appear live. Are we writing another question? We got another one in there. On the funeral pre-planning, you can do anything. You know, I always tell people you can do anything as informal as just saying, you know, play Amazing Grace and my favorite U2 song or whatever it is that you want done. But you can't actually prepay for those. You get a little bit of a discount. It's Medicaid friendly for those of us who do Medicaid planning to pre-plan your funeral, and of course it avoids that very awkward passing of the hat if it's not paid for, and your family needs to quick find somebody who can write that check.
Right.
So it's a very nice and just a better overall experience, certainly for the families, if you're able to do the pre-planned funeral stuff. We got
One more
got-
question.
We'll see what we can do.
Thank you. Okay. Oh, this one's a fun one. How do these estate planning tools impact someone going on Medicaid for long-term care? What issues if they don't have these in place, if they need Medicaid? How does real estate transfer work? How do trusts work, i.e. deprivation of assets?
Well, this is a major.
Lots of questions.
There's a lot of questions. This is a major area of my practice. How did you need your financial power of attorney. Getting through the Medicaid process, the spend down process, the allocation process will be incomparably, nearly infinitely more easy with a power of attorney than without one. So you all need to do your relatives that favor of giving them the power to actually move the assets and get them done. The will doesn't matter. There's really nothing you can put in a will that will affect Medicaid, because the will only takes effect when you're dead. Revocable living trusts generally have to be emptied out. So if you do that kind of planning and you end up needing Medicaid for long-term care, you're just going to have to abandon that trust. So it adds an extra step there. Transfers, and my practice has a variety of strategies to legitimately, within the law, transfer assets when it is safe. If you just transfer all of your assets and then go to the nursing home the next day, that Medicaid will not pay for that. That will not kick in. There will be a substantial deprivation of assets, deprivation of resources penalty, and it will not start until you're eligible. It is designed to be a very severe penalty. So if you are going to be giving anything away, you need to do so very carefully. Call me, and we can do that. If you have existing gifting, the people who really get caught there are the people who have given gifts in the last 5 years, have helped their kids out or helped the grandkids out. If you come to me, at least, or if you come to a good estate elder law attorney with that history of gifting, we can protect those gifts the same way we could do proactive planning and give some gifts to a limited extent. I can only do what the math and the regulations the law will allow, but we can often keep those gifts around. Frankly, if you were too generous, you will be in very large trouble. It's designed to be a very punitive system, and does result in unpaid bills if not properly planned for.
So people with significant assets of any kind that they want to plan for need to talk to him. People who don't have much, who really have modest means and don't have needs for trusts and things like that, call the statewide elder access line and we'll be happy to talk with you. So we also do powers of attorney and living wills. I'm sure you guys do them as part of your estate plans.
Lots of those as part of our estate planning. And if you have those pesky federal estate planning problems, if you and your spouse have a $22 million estate, that's just not covered at all. That's another lawyer at a big fancy firm.
I think we're out of time. Thank you.
All right, thank you so much.